Yes. Why not? Joe. I now deal with negligence in culpable homicide cases. In terms of Section 258 of the CPA, culpable homicide is a competent verdict to a charge of murder. In determining whether the accused was negligent in causing the death of the deceased, this court has to use the test of the reasonable man. In Burchell and Hunt, Principles of Criminal Law, 4th edition, the test to be applied to prove negligence is set out as follows. A, would a reasonable person in the same circumstances as the accused have foreseen the reasonable possibility of the occurrence of the consequence or the existence of the circumstance in question, including its unlawfulness? B, would a reasonable person have taken steps to guard against that possibility? And C, did the accused fail to take the steps which he or she reasonably have taken to guard against it. Page 409. Only if these requirements above have been met would the accused be guilty of negligence. Although the test for negligence is objective, certain subjective factors are applied. In S. v. Ngema, 1992, Volume 2, SACR 651, in brackets, capital D, the following appears in the head note. I quote, "While it is clear in applying the test of the reasonable man in determining whether or not certain conduct was negligent, the days of full-blown objectivism, in brackets, see, for example, R v. Mbombela, 1933, capital A, capital D, 269 at 272, close brackets, are past, and some evidence of subjectivizing the test for negligence is apparent. There is no warrant for departing holus bolus from the old and well-established reasonable man test. The reasonable man himself, of course, evolves with the times. What was reasonable in 1933 would not necessarily be reasonable today. What has happened in practice, however, is that the reasonable man is now to be placed in the position of the accused. It is not clear from decided cases, however, what is to be included and what is to be excluded from this position. A balance between the various ideas of what is to be included and what excluded from the test is to be included and what excluded from the test should be sought along the lines of reasonableness. One must test negligence by the touchstone of the reasonable person of the same background and educational level, culture, sex, and race of the accused. The further individual peculiarities of the accused alone must be disregarded, close quote. It was submitted on behalf of the accused that there could be no doubt that disability did not form part of individual peculiarities, and that therefore it must be taken into account in the concept of the reasonable person representing, I quote, a particular group of persons who are in the same circumstances as he is, with the same ability and knowledge, close quote. Counsel for the defense once more tried to persuade this court that the accused's disability, among other things, rendered him vulnerable, hence his reaction that morning when he armed himself with a firearm, and that therefore he could not be found guilty of negligence. As stated earlier, vulnerability is not unique, as millions of people in this country can easily fit into that category. In my view, regardless of what category of people we are dealing with, the answer to whether a particular act is reasonable or unreasonable has to depend on the particular case of each case. It was pointed out by counsel for the defense that the conduct of the accused that morning was brought about by a number of factors. For example, his bathroom window was not fitted with burglar proofing. Once again, that is not a unique feature, as there are many people in this country without any form of security at all. Of course, as a fight rather than a flight response person, the accused would not have been expected to run from the danger. However, there were other means available to him to deal with what he considered a threat to his life. Security personnel are there to deal with such threats or emergencies. All the accused had to do was to pick up his cell phone to call security or the police. He could have run to the balcony and screamed in the same way he had screamed after the incident. He was able to call security after the incident. There is no reason or no explanation why he could not do so before he ventured into the bathroom with a loaded firearm. Calling security, calling standard, and running to the balcony to scream for help and to attract attention probably would have taken as much time, if not less, as it took to go to the bathroom and to discharge those 4 shots. It is also significant that at the time that the accused had the window slide open, he was nearer to the balcony than to the bathroom. Counsel for the defense urged this court to consider the peculiar circumstances of the accused when determining the question whether the accused, by firing the shots, acted negligently. Growing up in a crime-riddled environment and in a home where the mother was paranoid and always carried a firearm placed the accused in a unique category of people. This would explain the conduct of the accused that morning when he fired shots at what he thought was an intruder, it was argued. I agree that the conduct of the accused may be better understood by looking at his background. However, the explanation of the conduct of the accused is just that, an explanation. It does not excuse the conduct of the accused. Many people in this country have experienced crime or the effects thereof, directly or indirectly, at some time or another. Many have been victims of violent crime, but they have not resorted to sleeping with firearms under their pillows. It also has to be borne in mind that the determination of what is reasonable and what is not reasonable would depend on the facts of this particular case. If the accused, for example, had awoken in the middle of the night and in darkness saw a silhouette hovering next to his bed and had, in a panic, grabbed his firearm and shot at that figure, only to find that it was the deceased, his conduct would have been understandable and perhaps excusable. In such a case, he would not have been expected to call security first, as he would have been faced with a real emergency. In this instance, however, this was not the case. The accused had reasonable time to reflect, to think, and to conduct himself reasonably. On the facts of this case, I am not persuaded that a reasonable person with the accused's disabilities in the same circumstances would have fired 4 shots into that small toilet cubicle. Having regard to the size of the toilet and the caliber of the ammunition used in the firearm, a reasonable person with the accused's disability and in his position would have foreseen that if he fired shots at the door, the person inside the toilet might be struck and might die as a result. Evidence was led as to how far or how near the deceased may have been from the door when she was struck by the shots. There was also a debate about what caliber ammunition was used. In my view, all that is not really relevant to the issue at hand. The accused knew that there was a person behind the toilet door. He chose to use a firearm, which was a lethal weapon. He was competent in the use of firearms as he had undergone some training. I now revert to the relevant questions. First, would a reasonable person in the same circumstances as the accused have foreseen the reasonable possibility that if he fired 4 shots at the door of the toilet, whoever was behind the door might be struck by a bullet and die as a result? The second question is, would a reasonable person have taken steps to guard against that possibility? The answer to both questions is yes. The last question is, did the accused fail to take the steps which he should reasonably have taken to guard against the consequence? Again, the answer is yes. He failed to take any step to avoid the resultant death. I am of the view that the accused acted too hastily and used excessive force. In the circumstances, it is clear that his conduct was negligent. I will have to stop here. We'll proceed tomorrow morning at 9:30.
Quiet, people.
Hey, you're out, mate. You're out. You're out. You can't say it, man.
But there's people in front of
you.
Room?
This captain is stupid.
get that guy off the box. It's over here. It's over here on this side.
What are you planning to do?
Yes? Just get him off the box. Yeah, off the box. Get off. Hey! Laurel, let him, point to me, tell him to look at me. Get off the box, get off the box. Get off the box. Yeah, he's coming out further. Bring the box out. And that guy there with the hat next to him.
Violence against women will end. Say something, guy. Yeah, but for push up.
Laurel.
No, Ian is.
It's going to take him a long time to get through here to the car. Yeah, almost there.
Queen Elizabeth, are you?
Don't say that.
Well, ma'am. Yeah. I'll drop off the ladder, go that way, you'll get it from that side. Alright? Yeah, Marlon? Yeah, I'm going to leave it, don't worry. No, just wait for me.
You might want to email TBW and tell them that the top of the hour might have to get pushed.
These people that are right, facing the right direction. Can I get out? It's the right direction.
Car won't take half an hour to get in.
Just be one,
Well, just stay there. I'll get you removed, okay?
Drop the microphone a little bit. Just drop the microphone a little bit. Just give us a level again.
Just behind the first line. Stay there, and then when he comes past, I'll stop on you.
Still one more, Laurel? Laurel, can I do one more? One more? No, I'll do one more. That's right.
Right. Stand there, right there. Perfect when you're there.
Okay, I think that's the car.
Fun. Instead of simple, it's actually comes to
You'll be wide. You'll be wide in the front.
Car's right over here. No, I just won't be on you for very long. That's all.
Alright.
Goodbye.
Yes, I should. Victoria, I'm very bad for you. Kom. Dat is jouw plicht om zo te doen.
yours.
Oi, oi.
Go! Go!
Oscar Pistorius will not serve a single day behind bars. Charge.